Oh, so we have
Call to order, St. Thomas St. John Board of Zoning Appeals for July 18th, 2022. All rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So could we do a roll call, please?
Bob Burleson.
Here.
John Kennedy.
Here.
Drago Popovic. Brendan Sheeran.
Here.
Mark LaRue.
Here.
Attorney Adam Decker.
Here.
Councilman Liaison Brian Blazak.
Present.
And Town Manager Joe Wizawati.
Here.
Thank you. First on the agenda, minutes for May and June. Everyone had a chance to review the May minutes.
Yep.
Make a motion.
I'll make a motion to approve.
Second.
All in favor?
Aye.
Aye. Opposed? June 20th, 2022 minutes. Everyone had a chance to read those? Okay.
Yes.
Make a motion.
I'll make a motion to approve the June 22nd meeting minutes.
June 20th?
June 20th, sorry. 2022.
Okay. I have a motion. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Can I abstain? I wasn't here.
Oh, thank you. First on the agenda, 2022-17 use variance from St. John MC 24-122 in sequence to St. John MC 2445 to allow dog daycare and boarding in property zoned R2 at 12930 Snowberry Lane, St. John, Indiana. Patrick Walsh, Brian and Eleanor Walsh. James Weisner is their attorney. I always say sorry about that. I always say your name wrong. I apologize. Please step up to the podium.
Good evening, Mr. Chairman, members of the BZA. My name is Jim Weiser. I'm an attorney, and my offices are at 429 West Lincoln Highway in Cherville. And I've been asked by the Walshes this evening to to assist them in this particular application. So what I'm going to do is just comment on several legal aspects of this, and then Eleanor will come up here and lay the fact situation for you and do it in a manner that's I hope gets the point across. I'm confident it will, and do it in a reasonable period of time. First of all, Mr. Decker and I had a conversation earlier this afternoon, and because I wanted to make sure that Adam knew what my position was as it relates to to one particular legal issue. And I don't intend, and I don't think Adam or I or the public would be real crazy about hearing us talking about legal matters and case law and things like that. That if that ever happens, it'd be at a different time and a later date. But what I wanted to make sure is that for purposes of the record and preserving the record, I wanted to indicate that a legal position that we have is that that this application process, in this particular instance, given the language of your zoning ordinance or in your ordinance itself, is not necessary, and that it isn't necessary for the Walshes to apply for a use variance. And Adam knows the basis of my argument, and I understand Adam's argument back to that. I just wanted to make sure that you were aware that, and that the record was made clear, that that was an issue that I want to preserve in the event this goes elsewhere or needs to go elsewhere. So that's the first item. The second item is, I know there's been comment and questions regarding the potential or the continued zoning of the property, or the underlying zoning classification. So I just wanted to make a comment on that because there's been concerns expressed that I've seen in media, social media, and likewise that people are concerned about the R2 zoning classification, and that the R2 zoning classification is going to be changed or potentially could be changed, and they don't want to see that happen. So I want to make it clear, excuse me, especially to neighbors and the members of the public, that this variance, were it to be granted, this use variance, excuse me, applies only to this one parcel of property. And Indiana case law is very clear on that. And I can just quote, I've got two cases here, and I'll certainly provide those to Adam if that's necessary. But the leading case says that a variance involves a deviation or a change from legislated zoning classification applicable to only a certain piece of property. So I want to make sure that we all understand, again, for the record, that this does not change the R2 zoning classification in the subdivision in any way, shape, or form. In the event that it were to be granted, it would apply only to that parcel of property and only upon the basis of the action that the BZA recommends and the town council takes in the event that they decide to do improve or to approve. So having said that, I will then turn this over to Eleanor Walsh to explain the fact basis for the application.
It should also be noted that we're just going to be giving a recommendation to town council, so we're not making any, they'll make the final decision. For whatever we decide to do from here, that will go back to them if it does go that far back to them. Okay, all right, thank you.
I'd like to begin by thanking all the board members and attendees for their time. My name is Eleanor Walsh. My husband Brian is here as well. And we are the ones applying for the use variance to operate an in-home dog care service. When we started this service in our prior home more than 10 years ago, we were attempting to fill a need in dog boarding that we would have liked to use ourselves instead of having a stranger come to care for our goofy Great Dane in our home. A home environment where a small number of dogs could live in our home, play together, and not be traumatized by kennels with concrete floors and cages. Dogs would not come back from their stay with us sick or hoarse from barking all night, and have sores on their legs and nose from hard floors and metal grated doors. A place where they could play together in a small group and make our home theirs for the length of their stay. Shortly after we decided to do this, a company called dogvacay.com launched doing exactly this, and we signed up. It was a need greatly in demand, and we have enjoyed being a part of this growing residential style, crate-free, and non-kennel service for the last 10 years. We are not and have never been a kennel. We made a decision to move here to St. John to be closer to many of our extended family nearby. We knew St. John was a wonderful community and looked forward to becoming a resident and continuing this service. When we started operating our service here, we were unaware that we needed a kennel permit, as we never needed one at our prior home, and we didn't consider ourselves a kennel. Upon doing research, we thought we were under the 6-dog limit to be classified as a kennel. We made every effort to not inconvenience our neighbors. We spoke with our immediate neighbors when we moved in and let them know what we were going to do and asked them to contact us if there was ever an issue. We try to make sure any neighbors having an event in their yard or even hanging out at their yards, or even hanging out in their own yards or pools are not inconvenienced by dog barking. Dogs are supervised outside. Dog barking is stopped quickly. If we have a guest dog that ends up being a bad barker, we do not take that dog again. During a typical day, dogs are outside on and off no earlier than 8 a.m. and no later than 10 p.m. They are not outside all day long. They are not outside after 10. We don't walk them in the neighborhood, but have extended playtime outside in our large fenced yard. They are inside our home when not in the yard. There is not a lot of traffic, as we don't provide Monday through Friday daycare. At the most, we have one guest that comes 1 day a week, 2 to 3 times a month. We have no plans to expand that. Our primary service is overnight stays, usually longer than at least 5 days. So there's generally not a lot of coming and going of vehicles, and most of our clients do not drop off and pick up at busy traffic times. We have had hundreds of clients and hundreds of positive reviews on DogVacay and Rover.com. We have also had many direct clients as well. We never had any complaints from our neighbors at our prior home. We do carry insurance both through Rover and our personal dog sitting insurance, and we require all dogs to be up to date on vaccinations and to provide proof of that. We also pay taxes on our income from this service. We feel like this situation has snowballed, and all we want to do is take care of a few dogs in a loving environment for people when they go out of town or experience an emergency. We have not and will not need to make any exterior changes to our premises. There is not and will never be any signage either. This is also our home and our neighborhood too. We don't feel like this service has or will change the character of our neighborhood or unduly convenience our neighbors, any more than a resident that has 5 personal dogs in their home. Again, thank you all for your time.
Thank you.
Is there anything else?
The only other matter that we have to present is, we would like to present to the board at this time a petition signed by a number of folks that are in favor of the application, if I could approach.
Certainly.
And with the submission of the petition and the testimony of my client, if there's any questions, we respond to them, or else happy to open it up to the public and have the public comment on it.
We'll get there. Mr. Decker, I have a question for you real quick. On the finding of facts, it's showing approval, not approval. I thought it was favorable or unfavorable from the standpoint, this has to go back to the town council, correct?
Well, so
That's what my impression was earlier. That's why I'm asking that question.
and that's correct. No, what the Board of Zoning Appeals will do tonight is ultimately consider the application, the presentation, any remonstrance, and will make a recommendation, either favorably, unfavorably, or no recommendation to the town council.
Okay.
As part of the responsibility and duty of the Board of Zoning Appeals, you must make those findings.
Okay.
And those findings that are made by the Board of Zoning Appeals essentially is the basis for that recommendation, whether it's favorable, unfavorable, or no recommendation. So the Board of Zoning Appeals will make findings, or, you know, I would advise the board to make those findings as part of any action it takes in relation to this application.
Okay, thank you for the clarification. Anything else?
No, nothing
Okay.
further.
If you have a seat, we'll open up for public comment.
I'm sorry, Mr. Chairman, can I
Yes.
ask a couple questions
Yeah, sure.
before? I don't know if this, Jim, is for you or for Ms. Eleanor. Can you explain, it's not a day by day, it's 5 days, so this is overnight boarding?
Our
Can you explain,
business-
can you go into that?
Yeah.
Explain that again?
Our business is primarily overnight stays. We rarely take daycare because we limit it to 5 dogs, so it's very hard to keep a steady business going. It's better to have the overnight dogs. It's easier on us, our community, and everybody else. So occasionally we'll take a daycare, but like I said, the only one we have right now, and don't plan to expand this at all, is once a week, a few times a month.
Do you have any dogs your own?
No, we don't.
Okay. And then you talked about income tax, that you pay income tax on any of the income you earn from this boarding, I'll call it
Yes, we do.
boarding. Your residency, is it still, do you use it as a business expense? Do you pay a higher rate than the 1% residential? Do you pay a commercial rate of 3% for your residents?
So, no, this is a residence,
Okay,
and we just pay residential. We don't pay property tax. We rent. My son is our
okay,
owner of the house and our landlord, and he pays residential property tax.
okay. Thank you. And then one question for Adam. Adam, we heard their attorney's position that they don't need to apply for this use variance. Can we get your take on why, your opinion?
Yes. Mr. Kennedy, so the ordinance at issue, which is both in the town code, it's also found in the ordinance, meaning the zoning ordinance, defines a kennel to be any premises wherein any person engages in the business of boarding, breeding, buying, letting for hire, training for a fee, or selling dogs and cats. That definition also includes the following sentence: 6 or more dogs and/or cats owned, harbored, possessed, cared for, or kept in custody of any person shall be construed and constitute a kennel. So, in my opinion, the town definition of kennel does not exclude business operations with less or fewer than 6 cats or dogs. For example, it's my opinion that if a homeowner runs a kennel out of his home but only boards 5 or fewer dogs at a time, that still meets the definition of a kennel under our zoning ordinance and the town code. Because of the use of the word any lot or premises wherein any person engages in the business of boarding. And that definition, I think, is intended to identify any type of boarding, irrespective of the number of animals that are being boarded at any one time. The sentence regarding 6 animals, I think, is, in my opinion, applicable to homeowners who are not in the business of boarding whatsoever, but just so happen to have 6 or more dogs or cats on their premises. And in that case, the town, by its definition, would deem that homeowner to be a kennel, to be operating a kennel. And so that's the issue that Mr. Weiser and I discussed this afternoon, and that's my opinion concerning the definition of kennel in our town code.
Thank you. Thank you. Any other questions from the board?
I have a couple. Mrs. Walsh, can you, I'm sorry for you to get up and down, but you mentioned that the dogs would, one dog or 4 or 5 dogs would stay one night. Would it be multiple nights or just one night, or?
Most of the time, it's multiple nights.
Multiple nights.
yeah.
And I thought you said that Monday through Friday, you wouldn't have dogs there?
No. What I said is that we don't provide Monday through Friday daycare, meaning we don't have a dog that comes every day of the week, every day in the morning and leaves in the evening. We don't do that. We only have one, what I call daycare client right now, and it's 1 day a week, 2 to 3 times a month.
1 day a week, okay.
So there's not a lot of traffic.
Comes in the morning and then leaves
You know, it comes very early in the morning and then picks up after 6 in the evening. Usually.
after 6, okay.
But the vast majority of our clients are with us for extended periods, anywhere from 3 days to a couple of weeks sometimes.
Okay.
And we've provided services for a client who went into labor 2 weeks early, so we took her dog, so she didn't have to worry about that and things like that. So, but our primary focus on the business is overnight. And we were doing a little bit more daycare in the beginning because we were building the business, but that's not generally what we like to do.
Okay, thank you.
Anybody else have questions? At this point, we'll open up for public comment. Has anyone signed in over there, Brian? No?
Don't have a
Anyone?
sheet. Must be over here.
Oh,
I'm not sure if everybody understands the process, that if you want to speak, you're supposed to sign in. There's a lot of.
well, if they didn't, they can still step up at some point and just identify who they are. Amy Schultz at 13131 Snowberry Lane.
Good evening. Hello again. I was here just a little under a year ago to oppose the daycare variance for Snowberry Lane. I think some of you may have been here for that, may remember. I don't know why people keep trying to run businesses in their homes on Snowberry Lane. After the last hearing, I said I was never going to come back to one of these meetings, but here I am. We've gone from children to dogs, but most of the arguments I made before are still the same and very applicable here. Imagine for a moment that this was your street and your neighborhood and how you would feel, and please keep that in mind when you make these decisions today. You'll probably feel exactly the same way we do. It's a quiet residential area, and we're very opposed to having a commercial dog boarding business on our street. There are many other areas in town that could be zoned appropriately for a business like this, ones possibly with bigger lots and more room to house dogs. From the prior meetings I attended to, I understand your standard is whether the variance will endanger the health, safety, and welfare or impede the normal use of the surrounding properties. I believe that it does, and these are some of my reasons why. There is the issue of increased noise. It is a residential area where people want to enjoy the peace and quiet of their homes. With increased people, increased clients, increased number of dogs, increased traffic comes increased noise. We don't want to hear dogs barking or crying. I understand she said that if they have a bad barker, that they don't allow them to come back again, but we still have to suffer through that current boarding with that bad barker. We want to be able to sit on our decks and our porches, or even tend to our gardens and do our yard work in peace. Incessant barking will preclude preclude us from enjoying those peaceful times in our yards with our family. Increased number of dogs means increased amount of feces, which in turns mean increased amount of odors. Unfortunately, it's something we have to address. That's a lot, the more dogs you have, that's a lot of stuff you gotta store until garbage day on Monday, and quite frankly, we just don't wanna smell it. I know she said they only have one daycare client right now, but if this variance is approved, it gives them the permission and approval to take in up to the maximum number that they're allowed under the variance. So they may only have one now, but they would certainly be allowed to continue it in the future and take in more. The main way in and out of Snowberry Lane is pretty much through Shilton Drive. When I came before you last year, I indicated that it's crumbling as you approach Snowberry Lane. Still hasn't been fixed since last year. It's extra people that really don't need to be in our neighborhood that are going to be using and deteriorating our roads that are already falling apart. I already have to weave around the cracks and the holes so that I don't pop my tires.
Fortunately, we don't have anything to do with it.
I know, but it's just something to consider because it is bringing more people into my neighborhood. So it is just something that it's more wear and tear on our roads. Sure. And, even if it's just one person now, well, in a couple months, they might have 2 or 3, and then, they may have different people all the time. So it's still more wear and tear on our neighborhood. The last one I wanted to talk about was how allowing this variance would be materially detrimental and substantially adverse to the surrounding property owners, decreasing the value of our property and making it hard to sell in the future, as people will be less likely to move onto a street that houses a business with increased noise, increased odors, and increased traffic, all of which interfere with the peaceful use of the surrounding properties. Nobody's going to want to move into a house next door to a dog boarding business, which will make it virtually impossible for us to sell our homes in the future. So I ask you, would you want to live next door to a dog boarding business, listen to the barking and the crying and smelling the feces? If you wouldn't want to do it, then please don't make us have to. And I would respectfully ask that you deny their zoning request. Thank you.
Thank you. Next, we have Bill Purcell.
I was waiting for
Mr. Purcell, if you, pardon me?
be on the agenda.
Oh, I'm sorry. Then you're not here for the next one. My apologies. It's not indicated here. Mark Shaw. Mr. Shaw, please identify yourself, address, etc.
Hi, I'm Mark Shaw. I reside at 12990 Sunflower. I prepared a written statement, which I dropped off earlier today. I just have two.
I haven't got to it yet.
I just have 2 points. There is an error, an omission, in fairness to Miss Walsh, that I would like to correct here. There's in the next to last paragraph, there's a sentence that ends with "since December of 2020." I would like to insert the word "presumably" after that comma and before the word "since," because the way it reads currently, it sounds like a statement of fact. And in fairness to Ms. Walsh, I do not know that to be fact, so presumably should be added there at that point. Secondly, the second point I want to make, and I'm not an attorney, but I just want to remind the board that if they do approve this variance, I understand the Walsh's attorney said it would only apply to their property. However, if there were other parties that wanted to start a business similar to Ms. Walsh's, whether or not they lived in our residential area or any other residential area within the town, that has the potential to be used as precedent to justify additional variances in the future. So I just wanted to remind the board of that.
Thank you. Marlene, I'm sorry, I can't make out the last name.
Hello. I'm just going to make a short statement.
Identify your name, address, please.
Oh, my name is Marlene Faulkner. I live at 8720 Shilton Drive in St. John.
Thank you.
I'd just like to say that I understand their love for dogs, and I think that's a great thing, really. We just adopted a dog, my mother did, and she's wonderful. But I would also like to say that I object to the town of St. John granting a license for Sarah Walsh to operate a doggy daycare and boarding at her residence at 12930 Snowberry in Sun Meadows subdivision. I've lived in Sun Meadows for 31 years. When my husband and I moved to St. John, we did so because Sun Meadows was a perfect location. It's set back off the beaten path. It's quiet and populated with many families. Families with children that continue to grow and move into our neighborhood. There's no place in our residential neighborhood for business as doggy daycare. I just object, and for her to operate this doggy daycare and boarding business. I'd like to keep Sun Meadows family-friendly, quiet, and keep our property values increasing. Thank you.
Thank you.
Sorry.
Next, I've got Frank and Fran Bradkey.
Hi, my name is Frank Bradkey from 13,000 Sunflower in St. John. I also dropped off a letter today, so you have a written comment from me today. I just wanted to state the fact that my wife and I both oppose the variance. Much like Mrs. Faulkner, we moved into a residential area, single-family homes. When we moved in, we signed a covenant, the restrictive covenants that apply to Sun Meadows. Unfortunately, I don't have a copy of that with me at the time, but I'm sure there were some items in there that would restrict businesses and or subletting or renting houses from someone else. So I think there's a couple issues there, but I want to be sure that we hear that we are against this variance.
Thank you.
Thank you, sir.
That does for the list. Is there anybody else here that didn't sign in that would like to make a public comment? Please come to the podium. Please state your name and your address, please.
Thank you. My name is Denise Snyder. I reside at 8847 Shilton Drive. I've lived there for 30 years. I apologize for not signing in. I would like to add my name if necessary. I dropped off a letter on Friday to each of you. I agree with my neighbors who have already spoken. I just wanted to address a few other issues. When Ms. Walsh spoke, she said that when they moved in, they notified adjacent residents, and I was never notified. My property is 2 lots over from the back of their yard, so my deck views into their yard. And I can tell you that reading what was online on the websites and the things that they posted, they say that they have over 20-some years experience in doing this at their other residence, and that they were unaware that they needed a license, which I find interesting. If you've had this business, you would be well aware of that. And I know they lived in Illinois. It's clearly a lot of information on their website, and I did some investigating into codes in Glenview where they lived, and there is restrictions in the kennel description that all plays into it. So my concern is that this business has been going on for well over a year, and nothing's ever come of it. And since we got our certified letters in the mail, I didn't see any cease and desist. It just continues. So I'm curious if they're allowed to continue running their business even while this is under investigation by all of you and the rest of the town. So that's a concern that I have. Are they allowed to continue at this point? And then when does a change come into play? I also wanted to mention that about the local ordinance, the attorney mentioned if it was 6 or more, it was considered a kennel, and that residents are allowed to have 5 animals on their property. When we moved in, and I've been in Sun Meadows for 30 years, we were informed that residents were allowed to have 3 pets. And my adjacent neighbors just to the north of me have always had 3. We've never had issues with their pets. They're always in their property, well-trained. But as a resident of over 30 years, why were we not informed that it changed from 3 to 5? And when exactly did that happen? How long ago was that ordinance changed?
Questions I don't have answers for, ma'am. I'm sorry. And I mean,
Okay.
Mr. Ducker knows when this may have happened. I don't know that. And the cease and desist portion, again, we're here in a different,
I
body
understand
than
completely.
what,
Okay, well, I would like to
Because
go on
regulate
record as
that.
saying I oppose the variance being approved, and I hope you were able to read the letter that I sent in. Thank you for your time.
Thank you, ma'am.
is there any, okay, please stand up. The person in the back, I can't see, I just see a hand. Come on up. State your name and your address, please.
My name is Janet Schindler. I live on Goldenrod Place. I'm here to, I live around the corner, so I'm not one of the immediate neighbors, but I have friends there, and one of them is not here, and I'm supporting her and my neighbors. I just want to point out a couple things. The first letter, the second letter, I don't know if it was posted, but I heard there was a second letter and there was some door-to-door again, trying to get the signatures again, which I feel is a little bit of intimidation, but the first thing, I love dogs on the first letter. We all love pets, a lot of them. I know people that love animals so much that they have 50 of them in a house, or 4,000 beagles they're trying to get rid of on the news last week. Lots of people love animals. This has nothing to do with loving animals. This is a sales pitch, okay? Premature, premeditated, all right? This was a year ago. From what I've read, it was a year ago. This was premeditated. They bought this house. It's premeditated. They knew they were going to start a business in this house, okay? This house, if you look on Google, it has 4 surrounding houses. They're attached. What happens with one of them moves out and there's a baby, newborns? These are young people that are moving in our neighborhood now. It's changing. We've been there at least 27 years, but the new people that are coming in are starting up all the new babies. All the new people are young. What happens when one of the people in one of those 4 houses have a newborn? How are they going to get them to sleep at night? What about the people that work nights? Are they going to wake up because one of the bad dogs is barking that they're never going to get again? But that's not going to help this week. That's not going to help now. Okay, I just want to point that out. The nice place for the dogs to live, to be cared for. Again, it's a sales pitch. When you pull up Google, the first thing you see is the name of a company on the bottom. The sales pitch, okay? The lot size. Nobody is telling us what size the lot size was previously. I don't understand if you have a business plan, if you have a proper business plan, you're not going to move a business that is, it's different being an accountant or a real estate agent and you're working in your house and nobody sees you all day long because you're stuck in front of the computer. These are animals that are going outside, and I love dogs too. My sons both have dogs. But this is a business that is going to cause a little bit of air pollution, a little bit of yard damage, a little bit of in-house damage possibly. These surrounding houses are going to change, and we don't know the lot size of the previous house. Did anybody mention that? I don't know. I don't know if anyone mentioned where they came from, where the previous house was. What if the previous house was acres? Acres. This house is not. It's an R2, and it's surrounded by it's connected to 4 houses. The business plan was not done well before they moved into this home. That's all I can say. The business plan was not planned out. The neighbors have been approached twice, door to door. To me, that's intimidation. Large fenced yard, attached by 4 yards. I just want to know what the previous lot was. I just want to know what where they came from, and because this is small. This is small. And snowballed, of course it snowballed, because the people that live around that house have a right. They have a right to know last year. They have a right to know before this, and again, business plan, poor business plan. That's all I have to say. I don't live there. It's not going to affect me. I live far enough, but I have friends in that circle that are very upset about this change. So that's all I wanted to say.
Thank you.
Thank you.
Is there anyone else who'd like to? Yes, ma'am. Please state your name and your address.
Hi, my name is Michelle Ray. I live at 8830 Shilton Drive. And I would just like to say, listening to her today, to the couple today, about all the things that they don't do or they won't do, but there's no guarantees. I've not yet seen a contract ever provided as to the types of services that they can expect from them, that their clients can expect, and what neighbors can expect from them. They may say anecdotally, it doesn't happen, we only have good dogs. I know a bunch of good dogs that bite people. I know when I go walking that good dogs come out after me. I know that when you're bit, there's things that me as a person can come to the town, file a police report, things can happen. There's no guarantees. We don't know who these people are. We cannot go to them. They have to protect their privacy. They're the clients. So what happens if a dog gets out, runs amok in the neighborhood, what have you? There are no guarantees to this situation, and for that simple reason, because of the anecdotal evidence seems to change based on the story given at that day, I refuse. I would like to add my objection. I do not feel that our community is a place for this type of business. Thank you.
Thank you, ma'am.
Is there anyone else who'd like? Please step up. Please state your name and your address, sir.
Kevin Victor, 8875 Cardinal Court, St. John's. We talk about these dogs, and you were saying if there's a situation where a dog's a barker or howler or whatever, then that dog wouldn't be allowed back again. But, it's not 5 dogs forever, the same 5 dogs. Like it might be dog 1, 2, 3, 4, 5, and then 2 weeks later it's dog number 9. So number 9 might not get along with number 1. So it's like we're kind of in an experiment. Like, which ones are going to get along, which ones aren't going to get along. It's not an experiment, it's a neighborhood. It's supposed to be for residential, it's not supposed to be for businesses. And just one other thing I'll say is our neighbors on one side of us, their dog barks a lot. And I think sometimes they get frustrated and they put their dog out in the yard. So now we can hear their dog even more. And another neighbor has a dog that has thunder. I understand dogs don't like thunder. When it's thundering, it's loud outside and you can't really hear the dog. But then the dog barks for like the next 4 hours because it's freaked out. So it doesn't really calm down. It's like 4 hours later, the dog's coming off the ceiling. And all I'm saying is it's my neighbor's dogs. They love their dogs. It's their dog. It's their only dog. I can understand that. But if we don't know what dog 1 is going to do with dog 9 or dog 15, it's like an experiment. We're always going to have to find out what dog gets along with what dog. If there's 2 dogs barking like crazy, is one going to go outside for a timeout? Is that going to be outside barking? And I just think we don't have a consistent situation. It's not like 5 dogs. They'll always know these 5 dogs get along and they're happy with each other. We don't know. And that's all. I just think it's a neighborhood. It's not a business. Thank you.
Thank you. Thank you, sir.
Please step up to the podium, sir. Please state your name and your address.
Good evening, gentlemen. Harry Blondin, 12930 Sunflower. My question is, you've been in business for a year in this home since you moved here, right?
Sir, drive support, please.
Okay. How many complaints to the police department have they received for dogs escaping from their yard, noise complaints, and so on? And is there a license, particularly with the town, for boarding animals? And what brought them out now to get the variance after being here for over a year and a half? Was it because they were caught by the town running the business, or on complaints from the citizens, the neighbors? This is what I'm interested in, because it brings down the value of all the homes in the area. For the citizens of St. John, I can't see you guys approving this. That's my opinion. Thank you.
Thank you. Would anybody else like to make a comment? Yes, ma'am. Name and your address, please.
Deborah Dzinski. I live on Goldenrod Place also. I moved 15 years ago here with my kids. They were small. We searched and searched and searched for the good place, you know, with good schools, good community. And I, too, also love animals and pets, and I think they should be treated correctly. And I love where I live. I love my neighborhood. I'm proud of it. And I just believe that, I know that 15 years ago when I was looking for a house, if I would have known that I was moving in next door to someone that had a business like this, there would be no absolute way I would ever have bought here. And I believe residential should be kept residential, because that's what we all, most, in my opinion, I think that's what people look for when they're looking for a place to live. And I just wanted to make that known, that I don't think that I'm not for this because of that. And I think business zones should stay business zones, and residential should stay residential. If you're running a business out of your home, I guess, as I just said that, I mean, I think it's different if you're running a business out of your home and there's no clients and you're just doing, you know, email and computer and phone calls. That's one thing. But to have traffic and animals and noise pollution and all those things, I don't agree with. So that's all I wanted to say. Thank you.
Thank you.
Thank you, ma'am.
Is there anyone else who would like to make a comment? Yes, sir. Please step to the podium. The name and address, please.
Good evening. My name is Tom Dombovich. I'm the original owner of 12931 Snowberry Lane, which is property directly across the street. Everybody before me has stated reasons that I agree with, including property value and everything else. And for that reason, I'm also against approval. The only, excuse me, comment I would like to add, I guess immediate means different things to different people, but up until 2 days ago, Saturday, as was already mentioned, was my first contact with Mr. and Mrs. Walsh when they came around to petition if I would support their approval. Thank you very much.
Thank you.
Thank you, sir.
Is there anyone else who would like to make a comment? Okay. We'll close public comment. Gina, are all the remonstrances in the packet?
Yes.
Ms.
right in the
Sergio,
packet.
I'm sorry, you always provide them, so that's why
Yeah.
they're all in there?
Yep.
Okay. I need to read, there's quite a few here, so bear with me. The first one is to whom it may concern, I, Patrick Martin Walsh, am the owner of the property at 12930 Snowberry Lane, St. John, Indiana 46373, in accordance with the lease agreement set forth on the date of January 1st, 2022. I hereby acknowledge that Eleanor and Brian Walsh operated at home business of dog boarding and daycare. This is permissible within the agreement that has been made between the parties, and I encourage the town to permit my tenants to continue to operate their business subject to provisions of St. John Municipal Code. The right to operate their business within the confines of the Municipal Code of St. John should not be unreasonably withheld. Eleanor and Brian are excellent managers of their business and have run their business for 10 years. They have a wealth of experience managing dogs in this setting, and is a primary form of income for my tenants. Signed, Patrick M. Walsh, 6/13/2022. Next one is from Brian. I'm going to butcher your last name, Brian, if you're here, but Benol, 12991 Snowberry Lane, St. John, Indiana, 46373. To whom it may concern, I'm writing this letter in regards to the application to Peace of Mind Pet Services for the zoning change, Sun Meadow subdivision, 12930 Snowberry Lane. As a resident and neighbor, I oppose the application of rezoning. Should the application be approved, there may be many problems, concerns that could arise from the zoning change. Some of the issues include, but not limited to, the change in permit. There's no going back. Number 2, should the owners relocate, any business could go on that site. Number 3, excessive traffic and drop-offs, and pickups. New structures such as kennels could be built on the property, which could cause odor and noise problems. Number 5, odor from pet waste. 6, noise from the multiple animals on the property. 7, animals escaping from the property could be aggressive. 8, should an incident occur, insurance claims could be difficult. Also, the neighborhood subdivision setting is not, in my opinion, the appropriate setting for a business of this nature. I would think a location in the country and more land and acreage may be more appropriate site for the dog boarding business. I know their letter to the community lists limitations as to the number of dogs that they would be allowed, as well as the hours the dogs may be outside. However, should the application be approved, there's nothing legally binding to hold them to these limitations. Dogs being outside at 10 until 10 can be very disturbing to others in the neighborhood, especially on school nights throughout the school year. This is nothing personal against the owners. I'm sure that they're very nice people. However, this is a neighborhood, and in my opinion, should continue to be zoned as such so that we can all enjoy this neighborhood has to offer. The center of the neighborhood is, in my opinion, not the appropriate place for such a business. Signed, Brian Benall. This one came from Denise Schneider. Dear Sirs, January 5th, 2022, I received certification letter from Eleanor Walsh and the legal notice of public hearing signed by Mark LaRue. Not sure how that got there, but please accept this letter as my written opposition to the requested use variance of this property located at 12930 Snowberry Lane, St. John, Indiana, 46373. In my opinion, this business is disruptive to my residential area due to excessive noise, increased traffic, and safety concerns of the residents of Sun Meadow subdivision. I have lived in Sun Meadow subdivision for 30 years. I feel this is a business that will detract from our family-oriented setting. It will decrease desirability to live in the neighborhood, and it will decrease our property values. I do not support the approval of this variance. I will be in attendance on the July 18th board meeting and will gladly speak on behalf of myself and like-minded neighbors. Thanks for your consideration, Denise Schneider. Dear Mr. LaRue, I have concerns about the residents at 12930 Snowberry Lane, St. John, Indiana, requesting a zoning change. I believe this is that's the second residence that has requested a zoning change. Sun Meadows is a residential area, and businesses need to stay in areas zoned for business. The residents of Sun Meadows do not need any extra traffic and noise that comes with businesses. I have to believe that the owners of this business knew they were moving into an area zoned for residents and not businesses. I am requesting that 12930 Snowberry Lane remain zoned as residential out of respect for the neighbors. Julie Leibner, 12961 Snowberry Lane, St. John, Indiana, 46373. From Daniel and Bonnie Zabarek, and I apologize, folks, if I butcher your last names. We live directly to the west of the Walshes. We are apprehensive about changing the zoning to allow business to operate in our quiet, peaceful neighborhood, although they may be well-intentioned and I'd hate to have hurt anyone's livelihood. We feel that once you open the door to a business being allowed to operate in a residential area, it allows for possibility of numerous unforeseen problems. Also, once a variance is granted and a business license is issued, what keeps the business owner from applying for changes that the variance that will not, applying for changes so that the variance that will further disrupt the neighborhood. Given the numerous negative ways that this variance can affect the neighborhood, I wish to officially vote against the variance change. Signed, Daniel and Bonnie Zabarak. Apologize again. We requesting that they reject the proposal variance for Peace of Mind Pet Services to operate dog daycare and boarding at 12930 Snowberry Lane for the following reasons. We moved this subdivision because it was zoned residential. Having a variance for commercial property opens up to pursue changes in the zoning. Our property value will affected downward. Our property value will be affected downward if there is any commercial property in the subdivision. All dogs bark and bite. There's no way that this kennel and boarding business can guarantee these dogs will not get loose, bark, or bite. This barking is disruptive to the neighborhood and may be dangerous to residents if dogs should get loose. Having multiple dogs in one location increases the chances that dogs owned by the residents will bark, making quiet enjoyment of the property non-existent. We are requesting that you reject the zoning variance. This is not a proper location for a dog kennel boarding business. David and Elizabeth Rabarzik, 12681 Goldenrod Place. Next one, dated July 18th. Dear sirs, my name is Mark Shaw, and my wife and I purchased the property located at 12990 Sunflower Avenue, St. John, Indiana 46373, October 2003. We have lived there since approximately that time. On Thursday, July 14th, an unknown party left a copy of legal notice for public hearing regarding the above referenced matter in our mailbox. Attached is the notice of that copy corresponds purportedly from Eleanor Walsh at 12930 Snowberry Lane, St. John, 46373, owner of Peace of Mind Pet Services, dated July 1st, 2022. In correspondence, Ms. Walsh stated, we carry specific insurance for the business. A copy of Mrs. Walsh's correspondence is provided Exhibit 1. My correspondence is provided to you to ensure that you are aware of the status of Peace of Mind Services as a business within the Indiana Secretary of State's office, and to notify you of my concern regarding the validity of Mrs. Walsh's claim of specific insurance for the business. In my opinion, the Board of Zoning Appeals has the responsibility to ensure that Mrs. Walsh does in fact have insurance she claims she does pursuant to St. John Code Section 24-614, G1, which states approval will not be injurious to the public health, safety, morals, and general welfare of the community. Obviously, the lack of insurance for Mrs. Walsh's business would potentially injurious to the general welfare of the community. On Friday, July 15th, 2022, I reviewed online public records from the Lake County Assessor's Office related to the 12930 Snowberry Lane, St. John, which disclosed the property was purchased in November 2020 by Patrick Walsh, presumably Mrs. Walsh's husband. A copy of the property card for this address is provided in Exhibit 2. Subsequently, I reviewed online publicly available records from the Indiana Secretary of State's office. Specifically, I searched for every business registered within the office of the state of Indiana that contained Peace of Mind in the name of the business. Search produced records of 83 businesses contained those words, but none of the business was named Peace of Mind Pet Services. The name of Mrs. Walsh's business is provided in her July 1st, 2022 correspondence. I found this concerning because as the former holder of the professional license issued in Indiana's Department of Professional Regulations, I was required to provide proof of professional insurance to obtain the license. To obtain the required insurance, I had provided my insurance company with the copies of the business, articles of incorporation on file with the Indiana Secretary of State's office. Consequently, I suspect the veracity of Mrs. Walsh's claim on her July 1st, 2022 correspondence that we carry specific insurance for businesses. A copy of page 3 of the results from the search Indiana Secretary of State records is provided Exhibit 3 in this page. It is significant because of the list alphabetically of the business name Peace of Mind Pet Services that was registered with the Indiana Secretary of State's office would appear on this page. Additionally, I reviewed Mrs. Walsh's publicly available online client reviews associated with her profile and rover.com, which she referenced in her July 1st, 2022 correspondence. Between December 1st, 2020 and July 14th of 2022, 34 reviews were posted, presumably by Mrs. Walsh's clients. One of these reviews was by a James L., dated June 1st, 2021, that stated Shelby stayed with Eleanor and was not a good experience. Actually, it was very bad. Shelby was attacked by a much larger black lab and was left with several wounds. The wounds were large to her neck and shoulder area along with her ears. The attack happened on Saturday night, and we were not notified until Sunday afternoon, and that was only because I contacted Eleanor to say that we were coming home early. Shelby is traumatized, and she's not eating or sleeping well since we picked her up from the vet in the hospital on Sunday. She had sutures put in her wounds, and recovery will be lengthy, and our vet bill is already around $1,000. My Shelby is a small fawn boxer and can be territorial at times, but she's never had an incident like this before in her life. We have already had to visit the vet a second time to check her wounds. We can't even put her on a leash, take her for walks because it'll rub on her wounds. 0 stars for our stay. I found this review to be even more concerning, not just because description injuries to Mrs. Walsh's client's dog, but because it contained no explanation why medical attention was not provided to the dog until after its owner was picked up, or because it contained no reference to Mrs. Walsh offering to cover the veterinary expense incurred by her client, but because this incident in the other reviews indicated Mrs. Walsh had been operating her business 2 blocks from my residence with no variance granted by the board, with no registration of her business with the Indiana Secretary of State's office, and quite possibly no insurance since December 2020. Presumably, if Mrs. Walsh's business was insured, her client would not have incurred said expenses or could have been reimbursed for those expenses. A copy of the review by James L. is provided in Exhibit 4. Copies of other reviews will be provided to the board upon request. I strongly encourage the board to conduct further investigations into Mrs. Walsh's claim that we carry specific insurance on the business and deny Ms. Walsh the variance until she can prove she has her business, in fact, is registered with the Indiana Secretary of State's office and can be proved that she does carry specific insurance for her business. Signed, Mark D. Walsh, 12990 Sunflower, St. John, Indiana, 46373. Eleanor Walsh. Hello, neighbor. This letter is explained. This is the letter that she sent out.
Chairman?
Do I need to read that?
Well, these are the exhibits that were attached to the remonstrance letter that you just read.
So we don't have to read those then. The last one I just read, ma'am? Mark Shaw. So these are all the exhibits. Okay. So the next one's Frank Bradkey. Dr. Frank and Mrs. Francine Bradkey, 13000 Sunflower Avenue, St. John, Indiana, 46373. It's July 18th, 2022. Mark LaRue, Chairman, St. John Board of Appeals. Dear Ms. Mark LaRue, thank you for the opportunity to voice our concerns regarding the zoning variance being discussed at the meeting tonight. First off, let me say that Sun Meadows is a single-family home residential neighborhood. Despite the fact that we do not have a homeowners association, every resident signed the form to agree to the established covenants upon their home purchase. This includes a resident now asking for a variance. We have a resident that knew what type of neighborhood they were moving into, now asking for a variance to run a business out of their home. In response to Mrs. Walsh's hand-delivered letter, we have a few issues. She indicates the name of her business to Peace of Mind Pet Services. When I searched the Indiana Secretary of State's website, there is no business listed as the name she has provided. She states that they have specific insurance for the business, but how is that possible if there is no actual business? On Rover.com site, where the Walshes have their business reviews, there is some sort of insurance provided that covers certain out-of-pocket medical costs for third-party injuries. Example, someone other than the pet owner, sitter, or dog walker. 28 years ago, we moved into a residential neighborhood. We specifically chose this neighborhood because of location, all single-family homes, and we agreed to the restrictive covenant governing our home and our neighborhood. That being said, we are not in favor of granting a variance to this residence. The resident knew where they were moving into, as she says recently, and I am sure that they signed the same restrictive covenant we all signed. I am forced to assume that this resident has already been running her business for some from their home after some concerns from other residents and are being forced to seek a variance. If there are any other concerns from neighbors, why would a variance need to be considered? Our concern center on the myriad of issues ranging from insurance issues, additional automobile traffic in a neighborhood, safety concerns regarding the number of dogs, and the fact that this is not a business district, but a residential neighborhood. We have no issue with these residents wanting to run a business, even applaud their entrepreneurial efforts, but not in a residential neighborhood. Lastly, the question then comes as to where this eventually leads us. If the variance is granted to one, how is it to be denied to another? And the zoning board are ready to grant variances to others with business ideas in mind. We end up with at a crossroads where the interests of a few outweigh the interests of many. In closing, I want to reiterate that we do not support the granting of the variance in our residential neighborhood, and we moved into the residential neighborhood and believe it should stay that way. Sincerely, Dr. Frank Bradkey. That's it. Thank you all for sending those. We do appreciate it. When I see this list come in, I'm like, oh my gosh, I got a lot of reading to do tonight. Are there any other questions? Comments? I guess we close public comment at this point. If the Walshes would like to step back up to the podium. Any questions from the board?
I'll be brief. Understand. I guess first of all, I should point out for the record that a number of the letters that you read, the people were also here and spoke. So I don't want there to be confusion that those were different people. They're all the same, or those that I'm referring to are the same. I've just made a couple of quick responses, although I'm not overly concerned about how relevant the one is. I do have, and I guess now we should submit it just because the issue's been raised, but here's the proof of liability insurance that they have for the business, so I'll submit that with an item of discussion. I sincerely mean this. I respect everybody's opinion that was expressed tonight. The interesting thing is that's all it was opinion. There was no evidence. There was no evidence of anything that they claimed could happen. In fact, most of the people said this could happen, this might happen, possibly happen, without any evidence in support of that. What is interesting is that, and I'm not making excuses for the Walshes, what is interesting is the business operated for a year without one complaint, without any complaints. Without any complaints from next door neighbors, without any complaints from people on the other side, without any complaints from people that live 2, 3, 4 doors down or half a block down or a half a mile away. There were no complaints. So that's the evidence. The evidence is if the business operated, and it was my client's misunderstanding clearly, but it was their understanding from having previously operated this entity in another state that it was permissible. They didn't think about it. They're not lawyers. They didn't think about it. They just came in, moved into Indiana because they wanted to live here, be with their family, and and as a result, they ended up having the business, and it operated for a year. Nobody said a word. There weren't all these dire consequences. There wasn't any loss of value in their property. There wasn't any public welfare that was harmed in any way for that entire time. So, although I appreciate their expressions of opinion, I want to make sure that we all understand that's all that it was opinion. There wasn't one shred of evidence that was presented. One thing I do want to clear up from a legal perspective, because it was raised by the one gentleman, Mr. Shaw. And I know you know this as board members, and I know that Mr. Decker knows it, and those of us that do this for a living know it. But any ruling, Board of Zoning Appeals decide cases and decide petitions on a case-by-case basis. A decision in this matter sets no precedent for a future claim on with the same factual background or the same facts that are presented. It's on a case-by-case basis. You're a quasi-judicial body under Indiana law. You determine cases as would a judge, a judicial officer determine cases. And the fact that one case is decided one way does in no way, shape, or form mean that all the cases are going to be decided that way. It's on a case-by-case basis. So those are the items that I wanted to bring up. I mean, I know Ms. Walsh wanted to make one comment, so I'll let her make that at this time.
So I actually have a couple comments. Two of the people who signed our petition in favor are what we determined our immediate neighbors, which was a question mark. Our immediate neighbors were the 4 properties that we border on our backyard. So we did inform them, and we talked with them, and 2 of the people who signed the petition are those immediate neighbors. The size of our previous lot, if that's even important or not, is the same as we have now. So we didn't go from a huge lot to a smaller lot. It's the same. I don't believe there were any restrictive covenants when my son bought the property, so that's not an issue. And just the final issue of the dog that was injured in our care, her vet bills were paid by Rover from completely. She initiated the fight that happened, and she wasn't a small dog. She was a boxer. She was like 40, 50 pounds. It was an unfortunate situation where somebody, a pet owner, wasn't forthcoming with us about their own dog's aggression. And she ended up getting hurt in the deal. So I just wanted to explain that. We took her to the vet, and we informed them. There's a lot of misunderstandings there. Reviews are reviews because, people can write what they want. But we've had one major injury in the 10 years that we've been operating. And that was it. But we took the dog to the vet. We provided care. We made sure Rover paid all the bills. And that's all I can say about it. So,
Thank you.
Thank you.
Can I comment, please? No, the public comments closed, ma'am.
The attorney did bring up an issue about no evidence versus...
We're not going to get down to that track. That's where we've made our comments. We have other questions. You have questions?
Can I ask a question? Can I ask a question?
I can't hear what you're saying.
Can I ask a question?
Oh,
Sorry,
yeah.
can I ask a question? So your client was operating in a business for a year. You say you had no complaints. Then why did this request for use variance come? If everything's been going on for a year, no issue, I'm just trying to figure out why now you're asking for a use variance.
It went on for a year, perhaps a little more, and then, as I understand it, and I'm not sure about this so I may have to let Eleanor comment on this. Was it animal control?
Animal control. There was a barking complaint.
So then, after it had been operating for a year, there was a barking complaint, and I'm just finding out. And so after you'd been operating for a year or more, animal control came by, and then she was advised by staff or animal control that, hey, you need to do something about this. You're operating a business in a residential area. That's when they came into the town.
Yeah. We immediately we were told we had to get a business license and a kennel permit. And we immediately went to the village. It was a Friday afternoon, the Monday. and filed the business permit application. I couldn't find anything for the kennel permit online. And when I handed it in, the lady that took the application said they'd get back to us. And probably not even a week later, Jenna contacted me via email to tell me that we had to file for this. So her initial email was confusing, and I thought we didn't. But then it was clarified by the town attorney, and they said we had to file for a use variance.
Just one more question. Until you got to that point where you were notified by animal control, did your neighbors know at that time that you were boarding animals, or did they just assume those were your 5 dogs?
The 4 immediate neighbors knew we were boarding dogs, and some of our other neighbors in the area knew we were boarding dogs in our home almost from immediately from when we moved in.
Okay, thank you.
So the immediate, sorry ma'am, the immediate neighbors, 2 of them signed in favorable of your business. The other 2 didn't sign?
No, one hasn't been available, and the other one, well, both of them hadn't been available, so we weren't able to get their signatures.
And how many, this is my second question, how many, sorry, please folks, I'm trying to talk. You had your chance. And I don't want to sound rude, but now we're speaking. My second question is, how many dogs did you board in that last year or so that you've been in an operation? How many dogs could you say?
I don't.
50, 100?
No, not 100. I'd probably say 50, maybe tops. I'm not sure. I can't tell you off the top of my head. I mean, initially when we moved here, it was slow. So it took a little bit of time for the business to build up.
Yeah.
And we've had slow periods on and off as well. So, and I don't have proof that I notified my 4 neighbors because I spoke to them verbally. And, somebody's having a problem with the term immediate neighbors. I'm talking about the 4 people that immediately border my backyard. So the one person here is not does not abut our property. She's one house down. I mistakenly thought that I had informed that person, though, because she was walking with her late husband at one point, and I thought I told them. When we first moved in. I may be mistaken because we spoke a lot to different people. But that's all I can say to address that. Any other questions?
No, thank you.
John?
Nope, I'm good.
Brendan?
I do not have any questions.
Okay. Let's please, ma'am, we're...
Can I just respectfully ask for a second, because that is
No, don't do it.
Ma'am, we're done with public comment. We're trying to move the meeting along. I understand your point of view, but I want to ask everyone to please just be quiet throughout the rest of the proceedings for this particular matter. If we have to, we'll clear the room. If we can't get people to just sit and be quiet and stop raising your hands, we're trying to move through this. We're going to hopefully make a recommendation one way or the other regarding this. On that fact, would someone like to make a motion?
Discussion, Mr. Chairman. The attorney brings up a very understanding point that you take every case as its own merit, and I appreciate that comment by him. But in my tenure on this board, whether it's a use variance or a development of variance of a garage, we always put in some sort of contingencies that says you cannot operate a business in that area.
Correct.
Just last October, the lady who spoke first had a daycare. Now, I understand it's different type of individuals. The Walshes addressed the traffic issue, but I just, at this time, it would be the first time in my tenure that we allowed a business in a residential area for this type of use variance.
Mr. Decker, we still have to read the findings of facts, though, correct?
I recommend that with any action or motion by the board that you incorporate your findings that
Okay.
support that decision. Yes.
John, would you like to take care of that?
Sure. Regarding use variance for 1290330 Snowbird Lane, I would like to make an unfavorable recommendation. The approval will be injurious to public health, safety, morals, comfort, or general welfare of the community. The use and value of the area adjacent to the property, including the welfare or the variance, will be affected in a substantially adverse manner. The need for the variance will not arise from some condition particular to the property, which it is as follows. The applicant did not establish that the strict application of the terms of the zoning ordinance will constitute an unnecessary hardship if applied to the property for which the ordinance is sought. The petitioner has not established the approval does not interfere substantially with the comprehensive plan of the town of St. John. That is my motion.
And motion, do I have a second?
I'll second it.
All in favor?
Aye.
Opposed? All right, Mr. and Mrs. Walsh. Thank you. Please, folks, if you're going to stay for the next round, the next portion of this meeting, that's fine, have a seat. But if you're going to leave, I'd ask you to leave quietly so we don't disrupt the proceedings going forward. Thank you. Next on the agenda, 2022-18 developmental variance from St. John MC 24-125D3 to construct a 12-foot by 23-foot garage addition that extends 10 feet past the 20-foot side yard at 8636 Fairway Drive, St. John. Kevin Kelbs, owner and applicant. Kevin, would you like to step up, please?
Hi, my name's Kevin Klebs. I do reside at 8636 Fairway Drive, St. John. I've been a resident for 20 years there, so I do wish to add on to my garage 12-foot wide by 23-foot long. I would like to make it known that in our little two-block subdivision that we are there, there is one home that has a 3-car garage, and there are 3 homes that have an 18-foot door, but a 3 to 4 car spaces inside of it. Just to understand that there are some issues, or there's some houses that have this type of size of garages. And that is my application.
So if you could please stand, we're going to have some questions for you. If you want to stay at the podium, thank you.
Okay, so my understanding here, you're trying to build this garage beyond your building, beyond the building line?
That is correct.
Any need for it, Kevin?
Just additional garage space, another car to be put inside.
You have a shed in the back?
I do have a shed in the back.
In the past, when we have granted, if that's the pleasure of the board, would the addition of the garage be uniform with the existing building? You said that, sorry.
You mean?
Same siding?
Same siding. There is a picture in the packet that would show the design of that new addition. Roof lines and what have you. That would.
And is that tree in front being taken out?
No. No, it can.
And if I'm correct, Sergio or Adam, the line of sight issue or the vision triangle is not affected by the building itself or the house itself?
That portion of the ordinance is not applicable to this structure.
Okay, thank you.
So that ordinance talks about fences, landscaping, things like that, but it doesn't mention an actual structure?
Correct.
But if you see that pine tree, that pine tree would block it more than
That seems like
that building, yeah.
That seems like it needs to be an ordinance update.
So you'd remove the sidewalk that's around that
Yes.
side? Remove that sidewalk?
Mhm.
You'd add on to the driveway?
I would add on as a wing.
Okay.
To tie into the existing drive. It would fall short of the sidewalk.
Okay. Sweep it back in?
Yes, yes.
Do you want to ask that question? So Sergio, this is a building setback.
Correct. There's a 20.
So the building setback is usually like, I'm speaking above my pay grade, is set in stone. So how does this work? Is it just for the structure itself, and then it goes back to the, is it just a bump out in the building structure that we're
The
approving?
building line is, there is a 20-foot building line. What they're asking to is to encroach into the building line with a structure, 10 feet.
The setback is 20 from that.
Correct.
Okay.
It's a corner lot, so that's.
Right, that's why it's a 20-foot
Yeah.
setback on that corner.
So we would limit, part of our contingencies, we would potentially limit the size of what is encroached, the 10 feet. I mean.
Not
what
to
would-
exceed the 10 feet.
Not to exceed the 10 feet on the square footage?
Correct. There is a, well, the square footage is within
Code.
code.
Okay.
There's a 10-foot easement. They're going to stay outside of the 10-foot easement
Okay.
there. And then you see the sidewalk, the inside of the sidewalk here,
Gotcha.
and then the parkway.
Oh, gotcha, okay.
And your curb line is here, roadway, parkway, sidewalk, easement, and your building line here. And this is your structure.
Got it.
It's not a fence, it's a.
Mm-hmm.
Any questions for,
Sergio, I'm sorry, Sergio, did John look at this? John Gill, Building Commissioner, did he have any questions, comments, concerns?
He did not. He did look at it. He did not have any questions, comments, or concerns.
Thank you, sir.
any questions for Mr. Kelbs? Am I saying that right?
Klebs. Close.
I'm sorry. I'm terrible
It's
with
all
last
right.
names. Mine gets butchered every day too, so.
Yeah.
More questions? Have a seat, sir.
Thank you.
Yes, sir. Did you say something, Brian? I thought you should listen. So I believe we had Mr. Purcell, sorry. You had a comment?
Good evening, members of the BZA. My name is Bill Purcell. I live at 8649 Fairway Drive, which is directly across the street from Kevin's zoning variance request.
Thank you.
Would this be considered a remonstrance then?
I don't know. We don't have a copy of whatever was distributed.
Well, I gave it to you so you could follow along, and you don't have to read it. I'll read it
gotcha.
for
You're
you.
not putting this in, you're going to read it. Okay, thank you, sir.
I've been in St. John since 16 years, in Indiana my entire life. We moved here from Cherville, and we kind of like it here. Regarding the 20-foot setback zone variance request by the property owner at 8636 Fairway Drive, there are 5 issues concerning this request. Character of the neighborhood, its negative effect on property values, the change would pose a threat to the health and safety of the neighborhood, the scale of the project is extensive for a corner lot, there exists no economic burden on the property owner sufficient to justify such a variance, the use of the requested variance in the neighborhood would interfere with other property owners' quiet enjoyment of their own property due to a corner wood shop, as is the desired construction use as stated by the property owner. The character of the neighborhood would be affected by increased traffic, noise, and visually unappealing odd addition to a corner home. In addition, it would present a negative impact on property values as potential future home buyers in close proximity would additionally weigh whether or not they wanted to look out at an odd-shaped corner property across the street from a home they consider purchasing. Adding a 12-foot by 24-foot section to the property as proposed would close the visual space on the corner considerably. This new hazard would affect not only traffic but the children in the neighborhood who would now be put at risk when crossing the street with a limited view to traffic. The property owner retired relatively young, so apparently has no financial need to build a workshop onto the side of his home to supplement income. The noise from this variance in the neighborhood would force residents to be subjected to the hammerings and sawings of a working wood shop on the block. In the best interest of the entire neighborhood, I ask that you deny this zoning variance. And if you'll turn the page, the very first picture is from Sidwell's Portico. We're all familiar with that. And Mr. Kleb's home is circled. And you can see the proximity of his property to the corner. Now just imagine that proximity to the corner once a 12-foot outcrop by 23, 24-foot long is added to the south end of that property. My property is catty corner, right in the right-hand lower corner. So I'm directly across the street. And if you turn the page again, you'll see two photos. The photo on the left, you can see Mr. Kleb's property has an X on his home. This is a view traveling south on Fairway towards the corner of Fairway and Prestwick. You noticed already, as it is, the limited oncoming traffic view from around the corner. Imagine it again, 12 foot longer than that. It's going to really reduce the visibility around that corner and be a hazard, especially to young kids. And we have young children on their bicycles in the neighborhood on a daily basis. Again, the photo on the right, again, shows an X on Mr. Kleb's home. The property owner's zone variance request directly impacts my daily line of sight. It's what I'm going to see every day when I look out the front of my home. This photo is from July 6th, and it does not show the required zone variance public hearing sign due to obscurity either by the tree or not being present at all. So there's a legal procedural violation there. There are others in the neighborhood who have voiced opposition, but not so much that they want to, in their words, cause a problem in the neighborhood. That's why they're not here. I strongly urge for the things I put forth that you deny this request. Thank you.
Thank you, sir.
Thank you, sir.
Is there anyone else here for public comment? We'll close public comment, bring it back to the board. Sergio, was there an issue with the sign being put up in his yard as far as notification of the?
Not that we're aware now.
Okay.
All requirements have been met.
Okay, thank you. Any other questions for Mr. Kleb?
Sir, can you address some of the comments that were made by the gentleman?
Sure.
Especially, we just had an issue about business in a residential.
Right.
neighborhood. He brought
Right.
up a term, corner workshop.
Yes.
Are you proposing?
I am a hobbyist woodworker. I do not make things in a production standpoint. I belong to a club. I enjoy woodworking. I would be doing some of that. I do it right now in my garage, and I would be doing some there along with being able to park my car in there when need be.
But you don't sell product?
No.
People don't bring it in for repair?
Nope.
That's a contingency I would like to put on if it's the pleasure of the board, and just to verify that no
Right.
business operation is running out.
No intent at all.
What do you
And-
usually make?
And again, this is not an everyday thing. It's a hobbyist thing. I mean, I'm out there every now and then. What do I make? Cabinetry. I have a lathe. Things of that nature. I mean,
Kids' toys, stuff like that?
yeah, yeah.
Rocking chair.
Go ahead.
Like I said, I built quite a few houses in St. John and the surrounding areas, and building septic lines are pretty much locked in stone. Line we don't touch. In fact, one time in Illinois, I was 6 inches over it and made me cut down a whole 9-foot concrete wall. So, obviously, the other guys can weigh in on this. I know what you want to do, and I'm usually a big fan of a guy doing whatever the hell he wants on his own property, but I mean, I think, you can see clearly the house was built to stay off the building setback line, originally. I don't know that I would be in favor of approving an addition going over the building setback line. And corner lots do create, typically, not in this case, typically you make the corner lot wider for that reason, because you'll have the building setback line on one side that brings you over further.
Right.
And that does, to Mr. Purcell's point, whether that's in our purview or not, as far as the definition, I would be concerned about the line of sight.
Right. Well, I would just like to make it known that tree there is quite large, and it's clearly blocking the view, and that we've not had any problems with anything of that nature. Also, as you can see on the print, I'll be dropping that garage back 2 feet, so it literally drops it even back farther than the front garage line. So I don't really see his argument, but he has his opinion.
When you usually do woodworking out of your garage, do you have your garage door open or is it closed?
I am always very courteous of my neighbors. If occasionally I will use a router, and I never use it late at night. I try to keep it within the daytime hours, especially now since I'm retired. Those can get noisy. I hear other neighbors doing the same, and I can hear it a block away, so I do know what that can sound like. And my intention is not to, again, I'm a hobbyist. I'm not a production here of, it's a fun thing.
And this new building, would you keep your door closed, the garage door?
I can very well keep the door closed.
Do you usually keep the door closed?
If it's nice out, I don't, but in the wintertime, obviously, I do, yes.
Yeah.
But, yes, my garage is heated now.
Can I ask how it's heated?
Gas.
So the chimney that comes out of the garage there,
Yes.
that's a gas
Yes.
vent.
And this subdivision you live in, it's just basically a horseshoe
It's one way in and
and one way,
circle
same.
around. 2
just circle
blocks
around.
wide, 2 blocks long.
Yeah.
That's up to Lake Hills.
And then it was built.
So Brendan,
Oh, okay.
explain to me your concern with the building setback line, just so I understand it better.
What do you mean?
Well, like the concern,
Setback line.
yeah,
We just don't, I mean, every house you ever build, you're bound to them. I mean, I never have the option of going a foot over it, on a new construction, which basically this is. You're adding a new construction to an old construction. I don't know that.
and Sergio, are you aware in your tenure here that we've ever gone beyond the building line?
In the past 17 months that I've been here, I'm not aware that the commission has approved anything over the building line.
But have we been asked to go over the building?
Not that I'm aware of in the last 17 months.
I mean, we
I
have
can't recall
allowed
the
over.
last 5 years since I've been on this board, so.
I mean, we have gone over.
And that
the
might be
setback
for
line.
new construction.
So
But what
I've
about
seen them,
existing?
Right.
I've seen the board approve a variance for,
For a fence.
when a footing is installed incorrectly over by a foot or 6 inches, I
We
think.
had that, yeah.
They've had requests for that come in, but not a new
That one
construction
last
or
year.
addition to an existing.
But just like the previous one, I don't want to start setting precedents. I know you take everyone at value. I'm just trying to understand what the implications are of going over potentially the building line.
And I understand where you're coming from, and that's why I asked Mr. Klebs, this subdivision, this configuration, is just one way in, makes a big loop, so there's not a lot of traffic in there.
No, there's no cross traffic.
Yeah,
There's no cross.
yeah, it just makes a big circle and,
And I think adding on to a house increases the assessed value, and a lot of subdivisions coming. And I know it's unique to this neighborhood, 2-car garages versus 3, but in all the new subdivisions, we're looking at a minimum 3-car garages.
Yeah.
But to this neighborhood, I respect the remonstrator's comments that there's only one other 3-car garage in here.
I think Mr. Klebs adding value by putting another garage, and potentially it could be, instead of a woodworking shop, it's where you put another vehicle in.
I just
And
want
it's
to
not on the street, or it's not parked out in the front of his house.
I just want to understand Brendan's concern
Yeah,
about the building.
and I
line
understand where Brendan's coming from.
Is, I mean, are we setting something for the future if someone comes in and says,
Like I said, like we previously talked about, it is case by case basis, but, you know, I mean, I just don't know how the strict, you know, the strict application of the terms creates a practical difficulty for the property. I mean, every subdivision you fall into, everything, there's building setback lines that we're bound to. I mean, at some point, what's stopping you from building lot line to lot line? You know, that they're there for several reasons, you know, infiltration for the water, the extra grass. I mean, there's a lot of reasons they set them. I mean, we have them in every subdivision, every new construction, everything is bound by. I mean, that's kind of like your hard line, anywhere you build. I don't disagree that it will add value to the home, so I mean, that could certainly be a consideration with you guys.
Yep.
I don't know what you guys think as well.
and what's the size of the lot? I know, is it R2? Is it?
It's 90 by 133.
By 133.
Oh, I'm sorry, it's right here.
If John didn't say anything, I mean.
John would be looking at the construction prints of the structure. This is a request to encroach into the variant, or.
But he's seen this and
into-
wasn't concerned about it. is what I'm
Not
saying.
with the construction prints, no. This is a request that was presented to the board.
You wouldn't even have thought
You
about it.
wouldn't have thought about
at
it.
all.
I looked
Okay.
at that particular part of the request. Looking more at the construction of the building.
And this addition does not exceed his allowable garage space, correct?
Correct. There's not a request for a variance for square footage. It's a request to approach into the building line.
Any other questions from Mr. Clubb? I can make a motion regarding the,
I will make a motion regarding development variance for 8636 Fairway Drive. I'll make a motion to approve the development variance. The approval will not be injurious to public health, safety, morals, comfort, or general welfare of the community. The use and value of the area adjacent to the property, including the variance, will not be affected in a substantially adverse manner. That the strict application of the zoning ordinance will result in practical difficulties in the use of the property with the following conditions. The addition will be uniform to the exterior of the existing structure. No business operation out of the addition. That is all my conditions.
I have a motion. Is there a second?
Second.
Let's do a roll call for approval. Sergio?
Bob Rolson,
Yes.
John Kennedy,
Yes.
Brendan Sheeran,
No.
Mark LaRue.
No. Motion doesn't carry. Unfortunately, I'm agree with Mr. Sharon from the standpoint of that lot line and the build-out from there. We gotta have some sort of structure. I apologize that you won't be able to do this, sir, but I'm in agreement with Mr. Sharon on that.
Should we make a motion to defer and then see we get a full quorum?
You can do
That's
that.
definitely an option, and one guy's missing. You can defer it, and depending on which way he goes. I mean,
So how do we do that next month?
I'm sorry.
Or can you?
Mr., can we do that?
I would not recommend that.
Okay, no, I'm sorry, then.
The board considered all of the evidence, heard remonstrators, and considered it fully. I recommend that the vote that was taken stand.
Okay.
Okay. Apologize, bad enough.
All right, thank you.
Thank you. Next on the agenda, 22-19, use variance from St. John MC 24-192 in sequence to St. John MC 2445 to allow a physical therapy medical office in use in the US 41 overlay district at 10033 Wicker Avenue, St. John. Paul DeBoer, owner, Ivy Rehab application, Kevin, I'm not sure, Bruschetta, I can't pronounce his last name, I apologize, attorney, and you are here.
I am not the attorney. I'm Dominic Agliardato. I am the facilities manager for Little Steps Pediatric Therapy. Ivy Rehab is our sister company. We currently have a location in Crown Point, Indiana now. We do pediatric therapy, so yeah, there's just an.
Let's stop right there, sir. So
yes, sir.
Your role in this is what?
I'm our facilities manager. I oversee all of our clinics.
Okay.
Yeah. So, Mr. Chairman, this needs to be, the public hearing needs to be
We're told
tabled.
this was canceled, taken off of the agenda.
Tabled, I got an email saying this was.
So the agenda item did not meet the public hearing requirements. They're going to re-advertise for next month.
Right, that's right,
And
correct.
notify the adjacent property owners. And so they're not prepared to hold the board is not prepared for a public hearing.
Right.
So.
Okay. So from that standpoint, we would probably then ask for a deferral.
Well,
They would ask for,
We don't do it.
it's up to the applicant. It's the applicant's application. If the applicant wants to defer because
Okay.
it cannot establish that it met the requirements
criteria.
for publication, the applicant can ask for that deferral, but that's, I would say it's appropriate at this time, before there's been any consideration of evidence or hearing.
Right,
to
that's why I
defer
stopped
matter
the young
to
man
another
from talking.
meeting, Not after the public hearing and consideration of that application.
right. Thank you, Mr. Decker. So with that said, I guess the question is, you would like to defer till you can meet the criteria? Because you don't have, you don't have the, all the information or the requirements to even present at this meeting.
What criteria needs to be met in order for us to open that
The
location?
advertisement, correct, Sergio?
Correct. The notification needed to be posted in 2 newspapers. The advertisement did not meet the qualifications to be put into the Post Tribune, and so the attorney is working with the local newspaper to get that re-advertised in both the Times again and in the Post.
Okay, so there needs to be more advertisement in order for us to be approved to open that
There needs to be
facility?
a completed process for advertisement. Correct.
Okay.
The process was not
There's
complete.
certain criteria that has to be met before you can present to the board, and you don't have all those criteria met to present at this meeting.
Okay. All right. I just, yes, I understand that completely. There's just such a need for pediatric therapy.
I understand.
It's-
So let's
Okay.
just keep to the topic at hand.
Okay.
What would you like to do?
I guess we'll defer.
I'll make a motion to defer.
Second.
All in favor?
Aye.
So come back next month.
Once you work with Sergio and make sure that you got all your stuff, you can do this at a later time and do this.
Yeah, we're working with the attorney. Yeah.
Yeah. So, okay. Next on the agenda, new old business. I don't think we've got any more of that. Is there? We'll also open for public comment. There's a gentleman in the back. Is there something? No. Okay. Okay.
How you doing?
If that we're done here. Adjournment.
Who's on the reading those letters?